If you want to, you can turn in your book to page 615. You don't really have to. This is not really a chapter per se in the book, but it is an exceptionally important part of the exam. I mean, if you think about it, you're getting a license from the Real Estate Commission. Do you think they care that you know their rules? Yeah, it's pretty important to them that you know exactly what they want you to do and what they don't want you to do. So if you look in the license law and rule comments, and somebody said to me, oh my gosh, we have to learn all that. Well, I hate to tell you, this is the short version. The license law and rule comments are the short version. The actual license law and rules is about 100 and some odd pages long. We don't expect you to memorize all that. What I have done is gone through the license law and rule comments in the back of the book and pulled out the things that I think are both important and not mentioned thoroughly elsewhere in the book. There are plenty of things in the license law and rule comments that aren't in these slides. Like, for example, all the rules about dual agency, designated agency, the depth of that. But we cover all that in so much detail when we go through the agency chapters. So I don't feel a special need to pull that out. But the things that I've put in this section are the ones that either aren't mentioned at all in the normal course of the chapters, or just aren't mentioned in enough detail. What I will tell you is this: if I thought enough about it to put it on one of these slides, you really need to know it for this exam. And some of this stuff will seem really silly, like knowing dates and knowing the number of hours and knowing the renewal fee. It is really super important, because here's the truth of the matter. You're going to get a question about it. And what's the easier question to get right? A question where you know the date you have to take CE by, or a question where you have to solve for how much cash a buyer needs to bring to closing? You've got to do 50 calculations to get there. Because those questions count the same. They have the same weight on the exam. So make sure you learn the things that are in these slides. That's why I wanted to go ahead and get it to you early on in the class. All right, everybody got a copy? Make sure everybody did. All right, so let's get started. The first thing we need to talk about is the requirement for a license. Who in North Carolina is required to have a real estate license? And basically, I've just really simplified the rule down here for you. If you look in the rule comments, it takes about 2 paragraphs for them to tell you who needs a license. It's anybody or anything being what we call an entity. A company is an entity. A corporation is an entity. How many of you have ever heard of an LLC? You know what an LLC is, or at least have heard the terminology. It's a limited liability company is what the LLC stands for. All of those are entities. Folks, pay attention to this. Any person or entity that wants to engage in a real estate transaction for somebody other than themselves and for compensation needs a real estate license. So, any person or anything that wants to do real estate needs a real estate license. If you create an LLC, and that LLC is going to be paid real estate commissions, does that LLC need a real estate license? Absolutely it does. That's what I want to make sure you see about this rule. Because if you don't understand that, one of the first things you're going to go out and do is create a violation for yourself. Because you're going to go to your accountant, and accountants are wonderful for what they're good at, which is taxes. They suck at real estate law, just like we suck at taxes as real estate brokers. Because your accountant's going to tell you, Chris, you've got to incorporate yourself. You've got to create an LLC for, it's going to help you with your taxes. It's going to help you with your liability. And Chris is going to run right out, and she's going to go to the Secretary of State's office, and she's going to create that LLC. And she's going to have her commissions paid to that LLC. And she's not going to get a real estate license for that LLC. Because she never thinks of it as she needs a real estate license. Because whose commissions does she think of them as? Hers. They're not hers if they're being paid to what? To her LLC. If they're being paid to her LLC, who's actually doing the brokerage work? The LLC, and therefore who needs the real estate license? The LLC. Now, does Chris also need a real estate license to engage in that? Because eventually the money that goes to the LLC is going to get to her, right? So what we're saying is they both have to be licensed. Does that make sense? Go ahead, Greg.
Assuming you have your license and you own the LLC, is it just a simple matter of filling out the paperwork and $10, $50?
So Greg's question is, assuming I have my real estate license and I create that LLC, is it just a simple matter of filling out the paperwork? I'm gonna come back and qualify the answer here in just a second, but the answer is yes. It's just a formality. Because we have two different types of licenses, two primary different types of licenses, which we're getting ready to get to. For people, we have broker's licenses, right? Every person who's licensed in this state is a broker. Every entity who's licensed in this state is a firm. Well, clearly we can't make Chris's LLC come take this class to get a real estate license. So basically, what we would require of that LLC is that the owner of the LLC has what? A broker's license. And then it would be simply a formality of filling out the paperwork. Now, and that's going to be the clarification that I put on it. So he said, would it have to be a non-provisional? And the answer to that is yes. That's the one kind of clarification I would need to put on that, is that in order for Chris to license that LLC, to have her commissions paid to it, she would need to be a non-provisional broker, because you can't have a provisional broker who owns a real estate firm. So what that means, folks, is you've got to broaden your definition of firm, because a firm is any non-person who's going to be paid real estate commissions. If you really want to distill it down, a firm is any non-person that's paid for real estate brokerage services. I've got 103 agents in my firm. How many of them do you think have LLCs that their commissions are paid to? What would you guess? A lot of them. Over 40 of them. So what does that mean about the number of firm licenses that are actually associated with this real estate firm? It's over 40 licenses just for the firms. Because if I'm going to pay that LLC, I have to make sure that LLC has a real estate firm license. And for that firm to have a license, then the owner of that firm has to have a broker's license. Does that make sense for everybody? Here's how you're going to make it make sense for yourself. How is the real estate commission funded? Let's get to cynicism. Cynicism always works. How are they funded? Because it ain't tax dollars. How are they funded? License fees. So do you think they would have a rule that would require more licenses to exist or less licenses to exist? More. So the answer to the question of do I need a firm license for that is almost always what? Yes. If those commissions are being paid to anything other than a person, that thing better be licensed. All right? Does that make sense? So don't hold licensure just as something for people. It's for, my favorite question that I get from brokers all the time, because not all firms have to have brokers in charge. Generally speaking, you can set up that firm license without a broker in charge if the only reason it exists is for payment of your commission. So if Chris sets that LLC up and the only thing that's happening is her commissions are being paid to it, as long as she's not a provisional broker, they're going to let her send the form in and she can create that firm. But now, if she was doing other things with that firm other than having her commissions paid to it, like for example, she's advertising the name of it. Like, do you have some catchy name that you'd want to call yourself in real estate? Do you? Not yet. So maybe it's Chris sells the triangle. Okay, that's what she creates her LLC. Chris sells the triangle LLC. No problem. We can pay Christine's commissions to Chris sells the triangle LLC. But as soon as she puts Chris sells the triangle LLC on that business card, she's advertising it. And now we've triggered a whole new set of rules. That firm has to have a broker in charge. And so I've had brokers come to me and say, well, you're my broker in charge. I said, I am the broker in charge of United Real Estate Raleigh. This thing you have created that now requires a broker in charge, I am not the broker in charge of that thing. So they may have to have two brokers in charge. They may have to have themselves and me. So it gets complex. You don't need to know that part of it for the test. But the part that needs to hit home here is that everybody and everything who engages in real estate activity in this state needs a real estate license. And the big two things that you're looking for on a test, are we doing it for somebody other than ourselves, and are we doing it for the payment of a commission? Are we doing it for somebody other than ourselves? Are we doing it for payment of a commission? That's what triggers the need for a broker's license. If we're doing it for free, do we need a broker's license? Can we list houses? Can you all go list a house for sale next week if you want to? Absolutely. As long as you're not charging a commission for it, you're free to do that. Can you list your own house? Can you represent yourself right now in buying a house and be paid the commission on it? Sure you can. That's what I mean. I say the rules, but you don't hear them. What does the rule say? Someone other than yourself. You have to pay attention to what don't look around at what happens out in the wild and say that's the way it is. It ain't. Why do you think real estate brokers want you to think you can't represent yourself and get the commission on it? Because they want the commission on it. They don't want you doing it. But the rule says you only need a license if you're doing it what? Somebody other than yourself and for compensation. Go ahead. No. Nothing? You can certainly represent yourself as a buyer. You can walk in and you can say, I'm representing myself as a buyer. I would like to be paid that commission. Do they have to pay you? No. No, they don't have to. Just because you can legally be compensated that way doesn't mean anybody has to participate with you that way. So it's the other thing you should understand. Okay? It's not, well, no. I'm asking from the perspective of, it's tricky in the sense that what you see out there is not reflected in the rule, but that's often the case on the test. And they know that when they write the test, and they prey on that. They want to make sure you're actually paying attention to what the rule is, not what you see when you go out there in the real world. Because the truth is, it gets really complicated when you're trying to represent yourself. Number one, remember the commission's being paid to who in the transaction? Which firm? The listing firm. And the only reason they're agreeing to share that commission is because they've agreed to cooperate with who? Another firm, right? Another selling firm. So they haven't agreed to compensate a buyer representing themselves at all. So they're under no obligation to compensate that person. That's going to be the first complication. They're probably just going to say, no, we won't compensate you. The second big complication for most buyers is that if you're financing that transaction, it's not going to be up to anybody other than your lender whether you can actually be paid that commission or not. Because put yourself in the lender's shoes. You're borrowing money from them to do what? To buy a house. And now you're telling them you're also going to be paid to do that thing. If you had a good friend, see, this is where the world is no more complex than just the everyday life. If you had a good friend who came to you and said, can I borrow $20 because I'm going to go down here and buy this thing, and then you found out that they were going to be paid a $5 commission as a result of buying it, what would you say to your friend? I would say, I'll give you $15 because if you're going to get paid $5 to buy the thing, you only need $15 from me, wouldn't you? And that's exactly what the lender's going to say too. So it gets very complex when you start representing yourself without a firm. I'm not saying it's easy, but I'm saying from the Real Estate Commission's perspective, it's certainly legal. Okay, that's what the rule is. So the different types of licenses. We are a broker-only state. Every person in this state that's licensed is licensed as a broker. We do have two different types of brokers. We have provisional brokers and non-provisional brokers. The only difference between them, and this is the first time where you have to study something you never thought you'd have to study. Post-licensing. This word right here. Quick question. Does that say continuing education? They are not synonyms. They do not mean the same thing. Do any of y'all work in like a big organization where people are super territorial? Like, that's my thing, you can't take it from me? Does anybody work in a situation like that or ever been in a situation like that? Guess what? 2 different organizations once you get in the real estate commission. One for post-licensing and one for continuing education. Super territorial. That's the way you should think of them because they don't overlap at all. So when you ask me a question like, oh, well, does my CE count for post-licensing credit? What do you think the answer to that question is? No, because they're different people and they don't talk to one another. Does your post-licensing count for CE? Does your CE count for post-licensing? Do they have anything to do with one another? No. You gotta know that they're completely separate. And I'll warn you about that and you'll still screw it up on the exam. Because it's hard when you're filtering through all this stuff. What I'm telling you is make a special point of it. Underline that word. Put an asterisk beside it. Because that is the word, and here's how I remember it. Provisional brokers take post-licensing. What do they both start with? P. Post-licensing is for provisional brokers, and only for provisional brokers. Because it's the classes they take so that they're not what anymore? Provisional. Those are the classes you take to get rid of the provisional status. There are 3 of them. They're 30 hours each. That's what's going on next door on the weekends. Once you have taken that 90 hours total, the provisional status drops away. And you can take that as quickly as you want to, folks. You can get rid of your provisional status as quickly as you want to. What's the maximum amount of time you can take to get rid of that provisional status? I heard the answer. 3 years. 3 years. So what do you think that means? You have to take 1 per what? 1 per year. And I'm going to give you the date that matters for that. Okay? Beside post-licensing in your notes, I want you to put license anniversary date. Just write that down. Because the other problem you run into with the Real Estate Commission and their rules about education is that every single rule has a different date tied to it. None of them coincide with each other, and you have to know it. Because what they'll do on a test is they'll give you the wrong date with the wrong thing. They'll flip-flop them, or the wrong number of hours with the wrong thing. They'll flip-flop them. So you have to remember, post-licensing classes are how many hours? 30 hours. And there are how many of them? And which brokers take them? Provisional brokers. And what is the date that you must take them by each year? Your license anniversary date. So whatever date you get your license, from that date you have 1 year to take your first post-licensing class. And by your second license anniversary you have to have taken 2. And by your third license anniversary you must have taken 3. Is everybody good with that?
So what happens if you don't take it? Do you just lose your license altogether?
No, Gray's question is, do I lose my license altogether if I don't take them? That actually used to be the rule. They have softened up that rule a lot. Again, what funds the Real Estate Commission? License fees. If you lose your license, you aren't paying a license renewal fee. Cynicism helps a lot in this business. You can answer half the test just based on cynicism alone, I think. I love them to death, but it's the truth. They changed the rule. Now you just fall inactive, which means you can't be paid. Inactive is a broad, big bucket category, which means you're not eligible to be paid.
So if you become inactive, all you have to do is take your 90 hours and then you get active status.
Exactly. Gray said, if I become inactive, does that mean I could just take my post-licensing, catch back up, and get back to active status? The answer is yes. The answer is yes. Okay? That's what inactive always means. Inactive always means you can get back, usually by taking some classes. Okay? Firm licenses. Anybody other than a person that's going to do real estate and get paid commissions for it needs a firm license. And so that could be like a sole proprietorship. That could be a partnership. It could be an LLC. It could be a corporation. But by the way, let's make a couple notes about how you recognize the difference between these different business entities. So maybe just in the margins on your slide there or somewhere on the bottom. So let's start with the most complex one, a corporation. Corporations have shareholders. This is a business structure where the business is owned by shareholders. General Electric is a corporation. Walmart is a corporation. Now, they don't have to be that big, but these are big business entities, and they have shares of stock which are sold them. The owners are the shareholders. Does that make sense? Now, working our way backwards, we have something called the limited liability company. Oh, I just realized there's a typo right there. Not compay, but company. The LLC, the limited liability company. Well, the first two words tell us what the primary goal is here. Why do people create an LLC? To limit or reduce personal liability. So what does that mean, personal liability? What is that?
So if your company gets sued, it will affect the LLC's assets, but not your personal assets.
Did everybody hear that answer? He said if there's a lawsuit that happens as a result of this transaction, it would be the LLC that would be sued, not me personally. And therefore, if there was a judgment, the judgment would be against the LLC and the LLC's assets, not me personally and my personal assets. So this is a business structure that is created to shield, I'm not going to say it always does, but it does shield the owners of the company from some liability. That's the purpose of it. Okay, so keywords there. The keyword for a corporation is what? What are you looking for there? Shareholders. The keywords for LLCs are members and managers. LLCs have members and managers. For example, I am a manager of the LLCs that own the Real Estate School and United Real Estate of Raleigh. They are both owned by LLCs, and I'm a member. I'm a member manager of both LLCs. A manager just obviously is somebody who has decision-making authority, whereas a member would be an owner who does not. And then a sole proprietorship would just be a single person creating a business entity. But the problem with a sole proprietorship from a liability perspective is if there's a lawsuit as a result of the transaction, who is the only, what's the direction of the lawsuit? Who's being sued? The sole proprietor, the person. The person. And partnerships are basically sole proprietorships just between more than one person. So a partnership would also not create that liability protection. Okay? So when you see those from now on, that'll give you some idea of their basic structure. You don't really need to know any more than that about how they function, but just kind of the buzzwords. Corporations going to be shareholders. LLCs are going to be members and managers. And then the last type of license that we've got here in North Carolina is an interesting one. The limited non-resident commercial license. The name of it is very descriptive if you break it down in pieces. It's limited. Means you can only do certain things with it. It's for non-residents, people who don't what? Live here in North Carolina. What kind of real estate you think it's limited to? Commercial. The limited non-resident commercial license. It's a limited license for people who do not live here and only want to work in commercial real estate. So, if you have somebody who falls into that category and they happen to be actively licensed in good standing in any other state, then they can apply for one of these licenses. If you have a person who does not live in North Carolina, that's the first rule. Because if you live in North Carolina and you want to practice any type of real estate in this state, what kind of license do you have to have? Which real estate license? A North Carolina real estate license. So, first rule, non-resident. Second, they are actively licensed in another state. Because even if you're a resident and if you're actively licensed in another state and you live here, it doesn't matter. You need a North Carolina license. So, first rule, they don't live here. Second rule, they are actively licensed in good standing in another state. Third rule, they only want to practice commercial transactions in the state of North Carolina. And finally, They have to have a North Carolina broker who's willing to take responsibility for them. Because remember, if the Real Estate Commission needs to discipline somebody, can they discipline a licensee from Illinois? Can a North Carolina Real Estate Commission discipline somebody who has an Illinois real estate license? Not at all. The only persons that the North Carolina Real Estate Commission can discipline are people with what? North Carolina licenses. So you would have to have a North Carolina broker to essentially vouch for you, to take ownership of what you do here, to take responsibility for you. Broker. Broker. I.e. non-provisional. Doesn't have to be a BIC. Any non-provisional broker can do that. Now, what are the obvious pitfalls of that from the North Carolina side? Think about that. Who can be disciplined? Whoever's taking responsibility. Exactly. Micah said whoever is taking responsibility for this person can be disciplined for something they did not even do. Think about it. If they don't know North Carolina law, might they break it? And who's going to be held responsible for that? The North Carolina licensee who takes responsibility for them. There's a reason this exists. The reason it exists is a commercial brokerage is generally not bound by state lines. Most of the time, most residential buyers are looking in fairly small geographic areas. And the people who need to move from state to state as far as licensees will have licenses in both of those states. If you practice in Charlotte, is it likely you probably have a North Carolina and a South Carolina real estate broker's license? Yeah, because you could just as well be having somebody look in Mint Hill as Rock Hill if they're looking at the suburbs of Charlotte. They're only, what, 10 miles away from each other? But one's in North Carolina, one's in South Carolina. If you sell houses on Lake Gaston where 2/3 of the lake is in North Carolina and 1/3 of it's in Virginia, might you have a Virginia license as well? Sure. But with commercial brokerage, these people often are searching 5, 6, 7 states at one time for the kind of property that their clients are looking for. So most states have this kind of an exception for commercial brokerage. It's limited to just commercial brokerage, though. This does not work in a residential transaction. If you want to do residential transaction in North Carolina, you need a North Carolina license. Okay? Everybody good on that? So let's talk more about the PBs, make sure we got everything nailed down. First of all, provisional licenses come on completely inactive status. That means you cannot do anything. Inactive means exactly what the name implies. You can't do anything. Absolutely nothing. You can't talk to clients, can't be paid, can't advertise, nothing. That's what inactive means. What status do you think you need to be on in order to do all those things? Be on active status. So, provisional licenses are issued inactive until the provisional broker does what? What does the next bullet point say? Affiliate with a BIC. You can't be active as a provisional broker unless you have a broker in charge. You've got to have a broker in charge as a provisional. So now, let me see how much your brains are working this morning. If I make a special point of saying in order to activate a provisional broker license, you have to have a BIC, what do you think about the difference between a provisional broker and a full broker? Do you think there's a difference there? Clearly your brains aren't working this morning because you're not saying anything. Would I not just say, in order to go active, all brokers have to have a BIC? But that ain't the rule. That's not what I said. What did I say? In order to go active, provisional brokers must have a BIC. So what do you think that means about full brokers? They don't need a BIC to be on active status. There's a reason I said just provisionals. Full brokers don't need a BIC to be on active status. They don't have to have a broker in charge. That's one of the biggest differences between provisional broker and a full broker. They can be on active status without being affiliated with a broker in charge.
Can they operate without?
So that's a whole different question. Grace said, can they operate? What can they do? Well, active status means you can get paid. That's really what active means. So what we're saying about full brokers is that they can get paid without having a broker in charge. The real question becomes, what can they get paid for? So think back to that agency chapter. Who represents clients in this state? The firm does. Firms have what? Contracts, but they have what in this case? BICs. Firms have BICs. So if I list a house, who lists the house? If I list a house as a non-provisional broker, who's actually listing the house? My firm. Does my firm have a BIC? Yes. So that eliminates, I can't do a listing without having a BIC, right? Yeah. That's eliminated. If a buyer client is represented, who does the buyer client hire? A firm. Firm has a BIC, right? So I've just eliminated, I can't represent buyers without having a broker in charge. There's one thing left out there on the sales side of things anyway. How about a referral fee? Do we even know what a referral fee is yet? Yeah. What is it?
Like if I refer, like if I have to have a license, and just to say you were in Charlotte, and I do real estate in Durham, and I don't do real estate in Charlotte, I send the particular client up there to see you.
Yep.
You sell the house, you send me a referral fee for referring him up to you.
Absolutely. Perfect description of a referral fee. AJ said that he, you need to come grab your slides over here. AJ said that he has a client or potential client who wants to buy in a market where he does not practice. He's licensed maybe because he was still in the state of North Carolina, but he knows nothing about Charlotte. He cannot, and by the way, that's the smartest thing I've ever heard somebody say about that situation. You know what the dumbest thing somebody would say about that situation is? Oh, sure, I'll sell you a house in Charlotte. Folks, if it's not your market, it's not your market. I don't care if you have a license that works there. You are doing a terrible disservice to a client by saying you will represent them in a market that you have no knowledge of. You just are. So, I don't know Charlotte. I'm going to refer this person to another broker. I find a broker I like. I think they'll do a good job. I have a conversation with them. I say, I have a client who's interested in buying a house up there. Would you be willing to share some part of the commission with me? That's called a referral fee. An active broker who does not have a broker in charge can do that. They can be paid that referral fee. Can they represent a seller? Can an active broker without a BIC represent a seller? List a property for sale? No, why not? Because who has the listing? The firm. Firm has what? A BIC. Can an active broker who doesn't have a BIC represent a buyer? No. They can only do what? Referral fees. That's it. Can a provisional broker who doesn't have a BIC receive referral fees? No. Can a provisional broker who does not have a BIC receive referral fees? Oh, no. And why can't they receive referral fees? Because they're inactive. Exactly. Exactly. Yes, ma'am, Mahogany.
So if you're a non-provisional broker and you have a LLC, a firm license, can you sell and list and stuff like that?
So Mahogany's question is, and these are real world questions. She said, I'm a non-provisional broker. Make sure I get it right. And you've created an LLC, right? Can she sell and can she list? And can she do all those things? Well, the answer to all those things is yes, as long as you have what? What do all those things require? All those things require a BIC, because who's going to be representing that client? Who's going to be representing that client? The firm. And a firm who represents clients, guess what it's got to have? A BIC. Bingo. See that whole like 8 slides that I showed you in chapter 7 where I kept saying the agent is the who? The firm. See, you better get out of this mindset that these clients belong to you. They don't. Even you don't belong to you. List your own house for sale. Leave your firm. Guess who that listing belongs to? The firm. That's going to be a hard lesson one day if you don't pay attention to it now. These clients are not yours. They are the firm's. That is the way. I'm not saying that because I'm a broker in charge. Actually, as a broker in charge, the last thing I ever want to do is hold somebody's listing hostage. If somebody left my firm, take it, please. But do I have to do that? Do I? No. I'll give you an example. I had an agent leave my firm 2 weeks ago. She had her own land listed. And she came to me on the day she was leaving. And she was leaving because she was moving to another part of the state. That's why she was leaving the firm. And I asked her, I said, Mary, don't we need to talk about something? And she said, what do you mean? I said, what about your land listing? She said, oh, my land? I'm going to continue to try to sell it. I said, so you're going to leave it listed with us? Oh, no. I'm going to list it with my new firm. I said, your new firm can't list what I have listed. Now, did I have any intention of keeping it? No. What I was trying to point out to her was what? She has to what? She has to ask. See, you know what your broker in charge says as soon as you walk out of the office? I'm going to share with you what the other side of the curtain. Mine. Mine. My building, my door, my office, my listing. I don't think of it that way because it's never been the way I've done business. But guess what? That's what the law says. The law says it doesn't belong to you. Not a single thing you do in this business belongs to you personally. It belongs to your firm. And you have to always approach it from that. I'm not telling you that to scare you. I'm telling you that so you understand the dynamics here. Because you can't answer Mahogany's question until you truly understand the way it works in this state. So now what is the answer to your question given that? Can you just go off and list property without a BIC? No. You've got to have one. There's your answer. Right? If you want to do all those things yourself and not have any interference from anybody else, what do you have to become? You have to become your own broker in charge. When I say you have to have a BIC, I don't mean it has to be somebody other than yourself. Guess what? I have a broker in charge. Guess who it is? Me. That's it. I am the BIC. Just like I'm everybody else's, I'm also my own. So you got to get in that mindset because that's the way the real estate commission approaches all this stuff. So I think it's a really good question. Does that help the answer? Understand the dynamics here. The transactions belong to your firm. So make sure when you go to a firm, you go to one that you're comfortable with. Have that discussion ahead of time. It's important to have the uncomfortable discussions ahead of time. What happens if I leave your firm? Do you let me take those transactions with me or do you keep them here? If they keep them there, do they still pay you anything for them? Because guess what? They don't have to. Not only does the transaction belong to them, the money belongs to them too. Your name's not going to be on those checks. Your firm's name is. And so you better make sure you have a written contract that says exactly what you're going to be paid under exactly what circumstances you're going to be paid. I have seen far too many people get taken advantage of in this business. It happens. Yes, ma'am.
So if that realtor, let's say she was staying with your company and her land sold, would you pay her a commission on her own?
Are you asking would I, Travis, pay her a commission or am I obligated to pay her a commission? Because they're two different questions.
I guess if it was in the contract, you would be obligated, but
Oh, no. I'm asking you what question you're asking me, and then I'll answer it for you. Which one, are you asking, am I obligated? You want me to get that one out of the way? I'm never obligated. Period. Who does the commission belong to?
Firm.
The firm.
even if you said you had a split with if the firm said they had a split,
Who does the commission belong to?
Firm.
The firm.
even if you said it,
It is a hard pill to swallow, ain't it? It sucks. Now, if you have a written contract with your firm and they don't pay you, could you take legal action against them? Absolutely, but they're not obligated to pay you any more than anybody's ever obligated to pay you anything. And if you depart their firm, you probably don't even have a contractual claim to that money. So you have to be very aware of these things. These things matter. And some brokers in charge are wonderful about understanding when you leave their firm. Some of them are vindictive and nasty when you leave. And that $20,000 you thought had coming at the end of the month, see ya. Wouldn't that be tough? You have to.
That's why you wait and leave when you get your money.
Tasha said that's why you wait and leave when you get paid. Woo, from the mouths of babes, right? You know, you have to protect yourself, because remember, you're always working in the name of that firm. You are. It's just the way it's legally structured. Now, there are plenty of firms where that would not be an issue. And I think you'll have a pretty good idea of which one you're working in, quite honestly. But do be aware of those issues, because the clients do belong to the firm. But the reason I also hammer that home is on a test, that will help you so much, because no matter how they pose that question to you now, who are you going to always say the client belongs to? A firm. Who's the money always belong to? It answers the question for you. Firms cannot have more than one BIC. A firm cannot have more than one BIC. There's only one broker in charge. Now, can I ask where that question's coming from? Because I want to make sure I'm not getting something wrong.
You made it seem like it's just something that any broker can do, so I just didn't know if there was anything that, if it was a huge firm like Keller Williams or something like that, if they could have more than one, so that there was like maybe groups in different areas or whatever.
So they could. Now, and that's why I wanted you to clarify where your question was coming from, because I don't want you to get the wrong idea in your head. Could I have more than one BIC in the building? See, we have to stop thinking of a firm as a building. Just like we have to, remember when we talked about property description, I said you have to stop thinking about neighborhoods as subdivisions, because a subdivision is just a plat map, right? And there might, even though there's 300 houses in a neighborhood, there might only be 10 lots on that plat map, and each plat map is an individual subdivision. A real estate firm is a BIC. So when you ask the question, can a firm have more than one BIC? The answer is no, because the firm and the BIC are pretty much the same thing. To the real estate commission, to those folks on the other end of Navajo Drive, I am the firm.
You're representing everyone.
Because everybody, I'm the umbrella and everybody's under me. But could there be more than one firm in the same building? The answer to that is absolutely. So we could structure ourselves, like for example, if I wanted to peel off and have a separate firm that just supervises my provisional brokers with a whole other broker in charge, I could do that. And that same firm could still do business as United Real Estate of Raleigh, but it would actually be two separate firms. So when you ask me the question of can a firm have more than one BIC, the answer is no, because a firm is a BIC, right?
And it has to be a separate name and everything?
It doesn't necessarily, it would have to be a separate LLC, for example. I could create another LLC that has a separate firm license with the Real Estate Commission and a separate broker in charge that supervises those brokers, but it could still do business under the umbrella of United Real Estate of Raleigh. So to the outside world, it would look like one firm. Just like when you go into a neighborhood, we call that a subdivision, right? Because to the outside world, we think it's all one subdivision when it really isn't. That's why I wanted to clarify where your question was coming from, because I don't want to give you an overly simplistic answer. Every firm has only one broker in charge, but you could certainly have multiple firms in the same building. You know, like even for example, in this building, I have 4 real estate firms, just that I'm the broker in charge of. Penn Realty LLC is the firm that owns the real estate school. Penn Realty Group LLC is the firm that owns United Real Estate of Raleigh. I have my own personal LLC that my commissions are paid to, that I'm the broker in charge of. And then I have another LLC that is for a firm up at Lake Gaston. And I'm the broker in charge of all 4 of them. So there's another question. Can I be the BIC of more than one firm? Yes, as long as they all do business in the same place, same physical address. I can't be BIC of 2 locations. Be the BIC of multiple firms in the same location. Why do I need them? Because I can't get 105. No, I'm just kidding. Why do I need them? I don't need them. I look at it the other way. They need me. Your firm is largely a service provider. It's a service you have to have. I mean, remember, you can't practice without a firm, right? You need the structure of a firm. And it's not the physical structure that you need the actual structure of a firm. So at least early in the business, you can't be your own broker in charge, so you have to have one. And then most people decide later on in the business that it's not worth trying to do it on their own because there are lots of expenses that go along with being a real estate firm. You know, there's errors and omissions insurance and just the responsibility of having that supervisory role with the real estate commission, and joining the MLS as a firm is much more expensive than it is as an individual broker. And there's a lot of things that go along with it. And so basically we serve a role. We fill a need in the brokerage industry as a real estate firm. I don't recruit agents because I need them. We recruit them because they need to be somewhere, and so we would just assume that'd be with us.
You're just sponsoring them.
I'm just sponsoring them. I guess that's sort of. Oh yeah. I mean, I think that's a fair enough way to say it. And supervising them, of course. Being responsible for them. Okay. You know, if you had asked me that question, Gray's question is there an upper limit to the number of people I can supervise? If he had asked me that question 3 years ago, I'd have probably said I certainly could never see anybody supervising 100, but I guess that better not be my answer now, given my current situation. I think it really depends on the structure you have within. Because even though I am the broker in charge of 103 people, I have at least... First of all, my whole staff is licensed. Everybody in the building has a real estate license. So they all can answer brokerage questions very responsibly. So they serve a lot of that role, you know, in that they know if they don't know the answer to the question, they come to me. But most of the brokerage questions they can answer themselves. So it's really in how you structure things and making sure that the agents are supported, you know, because as you know, what Sarah was really getting at is, you know, can you have other people of responsibility within the firm? And the answer to that is a resounding yes. Like, for example, Leslie, she is more than qualified to be the broker in charge of any firm in this state. She could run this firm with her eyes closed, just like I can. She's not the BIC on paper, but she certainly has all the ability, and my agents know that, so they go to her for just as much support as they do me. So, I mean, I feel like I have several BICs within my office. So, I think it's just really in how you structure things. I'd have to go back and look. Right now, I think it's 14. It's either 14 or 15 right now.
Don't you have to limit that?
I do, absolutely. That I very much limit. I do not take on just an absolute flood of provisional brokers because provisional brokers require more, you know, more hand-holding. You know, more supervision. Not only am I legally more responsible for them, you know, ethically I feel more responsible for them because they're, you know, they're brand new and they need more support. And so you just don't want to throw them out there to the wolves, so to speak. So, you know, we do two things with our provisionals. We encourage them to go ahead and take the classes so that they can get rid of the provisional status, number one, and we put them in a training program within the office so that we can, you know, get them up to speed so that newness wears off pretty quickly. But yeah, I do limit. I limit. The real estate commission doesn't, but I personally limit the number of provisionals that I would take on. Some firms won't take them at all. Some firms will not take provisionals at all. They'll tell you to take the classes first before you can affiliate the license with them, you know, just because there's a higher level of responsibility there. Okay, so you got to take post license, and each one by your license anniversary. Remember that in order to maintain active status. And any post licensing or any provisional broker who doesn't take their post licensing by those anniversaries, remember we said would fall to inactive status. So let's talk about the broker in charge a little bit. What are their responsibilities? Supervise all the activities of the firm. All the brokerage activities of the firm that fall under the BIC. Approve all the advertising done by the firm. That's a big one. Approve all the advertising. And look at the examples of advertising I give you there. What's the first one? Business cards. So every business card in my office, I have to do what? Approve. I've got to sign off on. They send me a proof before they print it. Ensure that all the licensees in their firm are on active status. Pay attention to that one because people tend to miss that one on a test. They think, oh, well, why would the BIC be responsible for making sure I have to pay my license fee every year, my renewal fee, or take my classes? Because ultimately, who represents the clients? The firm does. The BIC has to make sure the firm isn't sending an inactive broker out to represent that client. So yes, it falls to the BIC to make sure that everybody is on active status. So what are the qualifications to becoming a BIC? It's actually not very hard. I couldn't do it if it was. Number one, non-provisional. So how do you become non-provisional? Take post licensing. You can knock that out in a few weeks. The second one you can't knock out in a few weeks. You need 2 years of active full-time experience. So at whatever point in time you say, I want to be the BIC, what the Real Estate Commission is going to ask you to do is say, okay, over the last 5 years, do you have 4,000 hours worth of experience? Because they define a year of full-time experience as 2,000 hours. So they would say over the last 5 years. So it doesn't have to be like 2 full years. You could basically have been part-time for 5 years. As long as it accumulates up to the 4,000 hours of brokerage experience, then you qualify to become a BIC.
Is there a number of transactions that are required?
There is not a number of transactions. It's just brokerage experience. Because you could presumably have somebody who has no transactions but has significant brokerage experience. You know, like, for example, in my office, Karen has never done a transaction. She's been licensed for 4 years. But she's probably managed through our office, 500 transactions over the course of that 4 years. She's been involved directly with that many transactions because she's helped our brokers with them. She's done, she's been to inspection, she's been to closing, she's done paperwork with the attorneys. So, she would meet the criteria of being a BIC even though she's never actually had her own personal transaction because her role has been otherwise. So it's any brokerage experience. So 4,000 hours, but that's not what you need to remember. They call it 2 years. So 2 years of active full-time experience within the previous 5 years. So at whatever point in time you're saying, I want to be the BIC, they're going to look back to the previous 5 years. So realistically, how long after you get your license before you can become a BIC? A minimum of what? 2 years. And that's if you start working the day you get your license. So, and you'd have to start working full time in real estate the day you got your license. And then after you become the BIC, you have 120 days to take a 12-hour course from the Real Estate Commission. It's the only thing I know of where you can take the class after you become the thing. You declare yourself the BIC, and then you have 120 days to take the class. It's only a one-time class. You do it once, you're done. As long as you remain broker in charge eligible. Okay? So let's talk about unlicensed people and what they can do. Unlicensed employees of brokers. First of all, they can do most anything. Most anything. Not everything, but most anything that we associate with the responsibility of a real estate broker can be done by an unlicensed employee. First of all, they can place things in the MLS. They can set appointments. They can manage appointments. They can schedule maintenance. They can collect rent. They can make deposits in the trust account. Do you think they can balance the trust account? They sure can. They sure can. They can do almost anything. But these two down at the bottom, no. Number one, an unlicensed person can never negotiate. So they can't be engaged in any kind of a conversation. So here's what I mean by that. I don't have an unlicensed assistant, but let's say I have one. My assistant's licensed for this very reason. That way I don't have to worry about where those lines in the sand are. If I have an unlicensed assistant answering the phone at my firm, and somebody calls in and they're asking questions about one of our listings, can that unlicensed person answer those questions? As long as they're generic questions like how much is it listed for and how many square feet is it and how many bedrooms and bathrooms. Sure, they can basically just reading information to them. They can do that. If the person on the other end of the phone says, well, you know, do you think the seller is negotiable? Can that unlicensed person continue in that conversation from that point forward? No. They have to get a broker on the phone, because any answer to that question is considered negotiation. When you start talking about something other than the terms that are already out there, that's a negotiation. So you'd have to get a licensed person on the phone at that point. So you can't engage in any kind of negotiations. And then this last one's really important. You cannot show property that's for sale. So again, it's one of those things where I made a very distinct point of saying they could not show property that's for sale. So what do you think that means about other property? They can show other property, i.e. property for rent. They can show property. An unlicensed assistant of a broker can show property that's for rent, but they cannot show property that's for sale. There are also some people who are exempt from needing a license. If you are the salaried W-2 employee of the owner of the property, you don't need a real estate license to do any kind of real estate activity and be paid for it. So you could be paid a sales commission. You could be paid a property management fee. You could be paid any of those monies if you're the salaried employee of the owner of the property. Give me some exemptions. Apply a real world situation to that. New construction. Who's the owner of the new construction house? Developer, builder, right? And the people who are sitting in that office, could they be the salaried employee of the builder and not have to have a real estate license to sit there all day and sell those houses? Absolutely. That's an exemption. They're doing it for somebody other than themselves and they're being paid for it, but they don't need a license. That's what we mean when we say it's an exemption to the rule. Everybody okay with that exemption? Do you understand what I mean? They are the salaried employee of the owner of the property. That's one exemption. Another one is a trustee that's selling the property for something like an estate. So if I'm executing a will, for example, and I'm selling the property, as a result of that, I can be paid for that service and I don't need a real estate license. Or an attorney doing the same thing. But we always give one big note about attorneys. Attorneys like to think they're exempt from all the rules. They're not exempt from the brokerage rule. Attorneys cannot engage in real estate brokerage without a license. Here's what we mean there. If an attorney's been hired to administer an estate, and part of that job entails selling the property, can they do that and be paid a fee without a real estate license? What do you think? Read this exemption. An attorney performing legal services that involve... Does that sound like a legal service to you? If they were hired to administer that estate and the estate needs to sell property, can the attorney do that and be paid a fee for it? Yes. If somebody walks in their office and says, I need to sell my house, can you list it for me? Can they do that without a real estate license? No. We're not saying that attorneys are exempt from the brokerage rule. We're just saying that if they are doing a legal service, they are. But if it's strictly brokerage, they need a broker's license, just like anybody else. And they take the same test y'all do. And they actually fail it a lot more commonly than y'all do. You want to know what the pass rate was last year for attorneys taking the licensing exam? 22%. 22%. That's ugly, isn't it? Because they think they know everything. That's exactly right. They do. They don't have to take the class. They're exempt from taking the class. And so they don't. Guess what? They need to, clearly. 22%. Ugly number. So next time you see an attorney and they think they know everything, they're like, yeah, how many times did it take you to pass a real estate exam? If they ever tried. Okay? Is everybody good on these exemptions? Okay? Because they like to test you on stuff like that. All right? Let's take a quick break and we'll come back and pick this back up.